Today, we're back at the Sonny Bell trial, and we're going to take a look at the closing arguments of the state and then at least some small part of each one of the defendant's arguments. Here's what we're talking about today. I have to say, I think the defense strategy is it may have been the other guy's, but wasn't my guy. And I'm not sure how effective that's going to be. So the first person who got up to close, of course, was the state's attorney, and she made a number of good points. I wish I could put in all of the good points that she made, but the video would be way too long if we did that. So instead, I'm going to offer just a couple of the better points that she made, and then we'll move on to the defense closings.
2 minutes and 6 seconds is what it took to end the life of an innocent child and change the life of her family forever. 2 minutes and 6 seconds is what it took for the defendants seated before you, each and every one of them, to play a role in this case, in the murder of Sonny Bell, and in the attempted murder of her mother and of her uncle on Hillsborough Avenue on August 22nd of 2021. 2 minutes. The defendants, for 2 minutes before that, lie in wait, arm themselves with firearms, put on masks, wave each other on to enter the vehicles before jumping in to all of the cars depicted in the video that you've seen and chasing down the victims. They're charged with first-degree murder. They're charged with conspiracy to commit murder. The court will read to you the jury instructions that are applicable to the charges, each and every charge that you need to look at the instructions for, to determine whether the state has met its burden in proving to you that each of these defendants, regardless of who pulled the trigger, have blood on their hands in the death of Sonny Bell.
Now, I not only think that's a great way to open the case, it's also a great way to remind the jury who the victim is here, what happened to her, and how tragic it is. Not that you always want to play on the sympathies of the jury as a prosecutor, but you do want to keep the mind of the jury on exactly what happened to the victim here. And I think throughout her closing, she does a pretty good job of that.
This is Quandarius Hammond. Quandarius Hammond is the person who walks to the white fence line and crouches down there for just under 2 minutes waiting for James Denson to come back from his lookout point across the street. Just after the victim's silver vehicle passes, he exits the frame and then re-enters crouching down in that same spot. When you watch the video of him getting up from that crouched position, what do you know? The firearm that you have in your cell phone evidence depicted in the image on the right, photographed the day before, is in Mr. Hammond's hands. Here's Mr. Hammond. There's no point that the state will concede that there is audio to what the defendant's actions were from this video from the gas station. But what the state does assert to you is that it is plain as day what their intentions are. Mr. Hammond is pointing. Mr. Hammond is clearly communicating with the others nearby. And Mr. Hammond is clearly waiting to ambush.
Word choice is especially important when you're doing a closing argument, whether you're closing for the plaintiff or you're closing for the state. And here, the use of the term ambush is pretty interesting. In some respects, I think what she's trying to convey is they thought they were ambushing maybe another gang's car. I don't know. But ambush has a very negative connotation. When you hear somebody say, they were ambushed, you have to think, gee, that's awful. Nobody should ever be ambushed. And so her word choice here is very good. Also, listen to the clarity of her speech. She is definitely digging in with this closing and trying to make her points as best she can. And I think she's doing a pretty good job of it here.
So we first see on this vantage point the victim's vehicle at 9:04:27 p.m. It has driven past the Chevron coming east and made a U-turn and is now headed west back the other direction. 1 second later, we see Zavante Sampson's vehicle with Mr. Sampson as the driver passing this camera angle. Quandarius Hammond is the passenger of this vehicle, 1 second after the victims. Timing-wise, given they've made a U-turn from the location that's also depicted of the Chevron just up the road, there's no opportunity with a 1 second gap in the manner with which they caught up to have changed a thing. The defendants exit the gas station, and as Willie Brown testified, got right behind him before the U-turn. He did not think anything of it at that time.
One interesting thing that happened during the state's closing, or the initial part of the closing, was there was an interruption by Zavante Sampson where he basically got up and said, "I feel sorry for the little girl, but they were shooting at us." And I would point out there's absolutely no evidence of that, and the judge had him removed from the courtroom if he couldn't control himself. And he did examine him on the record and ask him if he wanted to stay, or if he had to stay, if he was going to stay, he had to be good. And essentially he said, "No, I don't want to be a part of this anymore." So they were going to let him watch that out on a television screen in a holding cell, which I think is a smart choice on the part of the judge. But you'll see this outburst right here.
He doesn't have special findings, but he has the same result. He's guilty of murder, just as are his co-defendants. We talked about motive versus intent. Motive is not what needs to be established. There are counts for which the intent of the defendants needs to be established. In principles to a crime, did the defendant help another person?
Taking it.
Now we get to a few snippets of the defense closings, and some of them were better than others. I have tried to select the part that was either very good or very bad from both of these or from all of these closings. And you have to forgive me. I don't like to go over 22 minutes with a video, but and as a result of that, I had to trim a lot of this. So forgive me for cutting as much of this as I did, but I can certainly recap for you what these folks said.
Good afternoon, ladies and gentlemen. I'd like to take a moment to thank you all on behalf of Zavante Sampson for your patience and your attentiveness over the course of this several-day trial. I'd also like to apologize on his behalf as well to you. This, to put it mildly, has been a very emotional process for everyone, and it has taken its toll on Mr. Sampson as well. You know, all of us have our commitments, and all of us have our jobs and our families and our personal obligations, our work. And as we sit here for these days listening to this testimony, the evidence, the admitted documents, the videos, I think that we all understand how important this whole process is. It goes without saying that I strongly disagree with the state's assertion and their view of what's seen in these videos, which are critical pieces of evidence for you to digest. After however many times they're reviewed and what they're alleged to show, it's pure speculation. I urge you to look very closely at all of these videos. They all bring something to the table, but I would suggest that you focus certainly on the Chevron videos, the East Tampa gun and pawn video, which shows the parking lot of the Chevron, the Lorenzo's garage video, specifically as it shows the interaction with Zavante Sampson's car and Willie Brown's vehicle. Because I believe that the evidence has shown you that it contains a great deal of pure speculation.
In just a minute, we'll get to the rebuttal closing, which will have a pretty good answer for that assertion. And other than that, I thought the whole idea about speculating about the video was a good point. But what this argument really boils down to is, who are you going to believe, me or your lying eyes? So there's that.
This is our opportunity to summarize what we believe the evidence has shown or not shown. And as Mr. Gonzalez just made a reference to, this is our last opportunity. Each attorney has one chance to address you for the defense. The state will always have that opportunity to address you one more time after all the defense attorneys have sat down. Obviously, every attorney wants to have the last word, but what I want you to be very aware is that if the state in the rebuttal says something, and I don't want anyone to please think, well, how come the defense didn't come back and address what the state just said? And the reason is that they have the burden of proof, and as a result of that burden of proof, they get the last chance to address you.
Congratulations, sir. You just re-explained again what your prior counsel had already explained, what the prosecutor and the judge had already explained. You essentially wasted time in your closing telling the jury what they already knew. This is not effective closing argument. This is a guy who doesn't know what to say to get his client off. And it's really kind of sad.
Distinct honor and privilege of representing James Denson throughout this trial. I asked you last week to consider the circumstances of the killing and the conduct of the accused. Because we have 3 distinct vehicles that you've heard evidence regarding, and we have multiple different people who may or may not be before you today who were inside of that vehicle. And each individual person, you're going to have to decide what involvement they had based on their own conduct and their own conduct only. And you don't need to take notes on what is written on this that I'm using for display, but you will be given a copy of all these things. But this is what it talks about when you have multiple defendants, multiple counts. And it says the charges against each defendant and the evidence applicable to him must be considered separately. And why is this important? On multiple occasions during our time here together, the government has used the word they as it pertains to evidence of intent, as evidence of overt action, and as evidence of a common plan. They masked up. They armored up. They went to war. However, because the law instructs us that you must take an individual analysis of each person's culpability as to each specific element of each crime, you'll be able to see that the analysis as it pertains to Mr. Denson fails. Because guilty by association is not a phrase that exists in this courtroom or back in the room when you go to deliberate. An irrational person should question why, whether under the facts of this case, the prosecution has made a blanket over this courtroom with the word they. So let's talk a little bit about jury instruction as it pertains to murder in the first degree. The annotations here are all going to be mine. So you will be charged that to prove the crime of first degree premeditated murder, And I'm asking you in your minds when you're discussing it with each other, where I wrote in blue ink, to say, as to James Denson, the state must prove the following three elements beyond a reasonable doubt. And the reason that we do it this way is for efficiency. But efficiency and convenience cannot trump my client's constitutional right to a fair trial. And any confusion in this area, even if we're being overly cautious, cannot happen. So when I say to prove the crime of first-degree premeditated murder as to James Denson, the state must prove three things. Number one, that Sonny Bell is dead. Okay, that's not going to be in dispute. But what will be in dispute is number two, the death was caused by the criminal act, which I have highlighted, of James Denson, which I also have highlighted. And you see I put X's under here where it says and or. Because even though we'll talk about principal theory and that's something like that, you cannot hold my client accountable if he did not intend for these crimes to occur.
I initially thought the reference in this to the communal they, when they were talking about the defendants, when the prosecution was talking about the defendants, I thought it was a pretty good line, and I thought this was the most cogent and most well-structured of the closing arguments for the defense. This guy did a pretty good job for his client, the best job that he could have done under the circumstances. And although the state has a good argument to rebut it, the fact is he might have actually raised some reasonable doubt here because he took it analytically, he did it using the jury instructions themselves, and he made the points about fair trials and due process. So, of all of the defense closings, I thought this one was absolutely the best.
What the judge has indicated, I believe a couple of other attorneys have indicated, what I say, what the state says, other attorneys say is not evidence. What is evidence is what has been introduced by the court or from the witness stand. That is the only evidence. If I indicate something to you that does not coincide with your recollection, use your recollection. It's not my intent in any way to mislead you or misinform you. There's been a lot of testimony, a lot of things going on over the last 6 or 8 days. So if my notes are not reflective of your recollection, use your recollection. Your recollection is what is important.
I cut several large portions of this argument out at the beginning because they were repetitive. This guy not only repeats the thanking of the jury for their time and attention and saying that how much they appreciate it, and he also mentions again that the state gets the last word. Again, that's already been said twice now. And he adds to that, use your own recollection. Well, what other recollection are they going to use? A lot of what this is just they're struggling for something to say to overcome the evidence here. And I think the problem that they have is that there's a great deal of evidence and they don't know how to attack it as to their client. And so what you're left with is, honest to goodness, my guy didn't do it. Don't believe the video. It doesn't mean anything. And let's move on.
Over 30 days before any arrests were made in this case. That's some testimony that you heard from Detective Salea. Way longer than the first 48 hours after the incident involving Sonny Bell. You heard his testimony about the media coverage. In fact, Ms. Ismer showed you the photograph of Sonny Bell that was used to try to get help from the public to solve this case. As you can imagine, with the death of a 4-year-old, there was tremendous community pressure to make an arrest. That's what led to what you've witnessed these past 2 weeks. Assumptions and speculation.
So we're going back to the assumptions and speculations theme, which is essentially ignore the videos, don't watch the videos, they don't mean anything, and don't draw any inferences because you can't hear any audio. Again, I'm not really sure how effective that will be, but I expect there will be a long deliberation in this case. Now we get to turn to the rebuttal to all of these rambling, somewhat incoherent closing arguments from the defense. And we have Assistant Attorney Terry, with numerous years of experience here, to wrap it all up for us.
Ladies and gentlemen, I'm in a unique situation, and one that after 33 years as a prosecutor, I've never had before, which is that I now have to rebut 5 experienced criminal defense attorneys who have all gotten up here and talked to you. Very rare to have to rebut 2, much less 5. So bear with me. I don't intend to keep you too long because you all have already heard and seen all the evidence, but I think there are some things that they said that do need to be countered. So first of all, one of the things that strikes me, when I was young, and I used to hear this a lot more when I was younger than I do nowadays. I'm not sure what that says about me or the world or whatever it is. But when I was young, I used to remember hearing, my parents or other people say, actions speak louder than words. Not sure if you've ever heard that phrase, but that was a common phrase when I was growing up. Actions speak louder than words. A number of these defense attorneys here have told you and talked to you like, well, we don't see any agreement. There's no text messages. Well, of course there's not. They're all standing next to each other. We don't hear a wiretap. Well, of course not. This all happened. This conspiring all took place within that brief period of time while they were in that chevron. Actions speak louder than words. Look at the actions of those individuals. What were they doing at that time? Watch it. It's very clear. The victim's car is driving by, and immediately you see 3 of them run out to that field to check out what's going on, including Zavante Sampson goes out there as well to look. And they go out there and they look. James Denson actually goes way across the street to see exactly where it's parking. And their attention is immediately drawn to that car. And then they're going back. James Bedward is so excited running back that he actually trips and falls. And they're all getting animated. You can watch that video. You can sense it. You can feel it. You can see it. They're pointing. They're waving. All of those actions indicate a common purpose. They are all deciding what they're going to do. They are all getting together and they are all planning to go after that car and shoot and kill whoever is in that car. There is no doubt about it. Watch their actions. Yes, we can't hear what they're saying, but look at Zavante pointing at the car as it's going by. Look at him when he's in the driver's seat going, come on, let's go, let's go, let's go. What is he doing? He's trying to get them to hurry so they can catch up that car and shoot that car. Actions speak louder than words. Those actions, the way they all got there, the way they waited till the second car showed up before they all left together. 3 cars loaded with guns. You saw them all grabbing guns. Actions. They're all what are they getting those guns for, ladies and gentlemen? Just to play around, do a little target practice? They're all arming themselves. They're all watching that car. James Denson, who Mr. Fischetti wanted to say, oh, well, my client, what was his conduct? What did he do? You know what he did? He was the one who went the farthest down there to watch that car. And he came running back to tell him what that car's doing, where it is, where it's going to happen. And if you watch him, he goes behind the dumpster, where they keep all the guns. And he's there right next to Quandarius Hammond, who's holding a gun. They all knew what's up. They all knew the game. They all knew what they were going to do. There's no question about that. Mr. Denson goes back to his car. Why do you think he went back to his car? To get his baby, to get his gun. He grabbed his gun and goes running back and jumps in the car. He was not going to be left out of this. Watch the excitement. Look at the people left behind, cheering him on. Go get him. Woohoo! Watch them. It's incredible. They're all geared up and excited. They're all working in unison. And we say they because it is a they. Yes, you are, under the law, required to consider each one of their guilt or innocence individually. But in this particular case, especially since they're charged with conspiracy, you have to look at their actions in concert and what they're doing together. They were coordinated. They knew what their purpose was. They knew what they were planning to do. They each followed each other out of that chevron, and they went. There were a lot of cars. There were other cars on Hillsborough Avenue. All three cars went to one particular car and shot it up. That wasn't a coincidence. They all left from the same spot, loaded with guns, and they all went after the exact same car. Because they had talked about it. They had gotten together. They knew what they were going to do. You see the guns. You see that AR rifle that Jalen Bedward's walking around with. You see the gun that Quandarius Hammond arms himself with. We showed you a picture from his phone the day before with that gun, or with the picture of the gun. They knew exactly what they were doing. And their purpose and their intent was to kill whoever was in that car. And I said to you in opening, and I say to you right now, I don't believe they knew Sonny Bell was in that car. I don't believe they were targeting a 4-year-old girl necessarily. But they were targeting whoever was in that car. Sadly, it happened to be Sonny Bell.
If you have the time and you want to do this, definitely go back and watch the rebuttal closing argument here. I thought it was very, very well done. I've done just the first couple of minutes of it, but you can tell he took good notes and he addressed anything he thought might hurt the state's case, and he did a really good job of it. It's now up to the jury. They've been instructed and they've been deliberating. I don't expect that we'll get a jury verdict today, simply because there are numerous counts, there are numerous defendants, and each defendant has a different indictment from the others, even though they're all tried in the same case. So I suspect it will take the jury a while, if for no other reason than just to do the paperwork. Again, I want to caution, they didn't tie the gun that killed Sonny Bell to a particular individual, and they didn't show who pulled the trigger. So essentially, they are blaming everybody for the actions of at least one person, maybe two. Hard to tell how many bullets actually hit her. I'm not sure. But the bottom line is, that is in some ways an unfair way to go about trying to hold these folks accountable. We'll have to see what the jury thinks about that and what kind of verdict they come back with. Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee. Anything that makes their day better. That would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.